Welcome back to Morning Express. This is the Weekend Review. Let me introduce my panelists once more. In the studio with me, to my immediate left is John Kogucha, who is a Speaker of the Nyeri County Assembly. Next to him is Honorable Esther Passaris, Nairobi Women Representative. And joining us now is lawyer Dr. Alutalala Mukwana, who will help us demystify some of this legal jargon that is coming into play. Many thanks for joining us, Dr. Mukwana.
Thank you.
So before we went on break, Honorable Passaris, you had something else to say.
Yeah, I mean, for me, Chiloba, all right? I keep saying that I don't understand why we need to have him there. We already have spent 40 billion, okay? We've already approved another 10 billion for the elections. This is a lot of money. We can't even afford to pay our nurses. We have a lot of issues in our country that need resources. Somebody who was responsible for bungling the first election, the first one, 2013, now again 2017, and we want to give him another election? What is so special about this man? He's like a pawn. Remove him from the elections. Let us have somebody, because they, as far as I'm concerned, they need to be charged. These guys have committed a criminal act, because at the end of the day, the process is everything. You can't say, oh, it's the end results. We have so many petitions. Why? Because a lot of people are feeling that this whole process was not right. So let's get the process right. Let's get the right people in IEBC. Let's conduct the elections. Let's get the right president. Because as far as we're concerned, the president that we believe won as NASA is Raila Amolo Odinga. But we can't even be able to tell that because they won't even open the servers. Why won't you open the servers? If your process was transparent, why were you refusing to open the servers? A lot of people are attacking the judiciary, but the judiciary is saying the onus was on you. Open the servers, show us what's in there. Respond to Chibukati's memo. At the end of the day, irreducible minimum, Chiloba must go. Why do we need Chiloba for the next election when he obviously bundled the previous one?
Let's hear from you, Dr. Mukwana, and let's begin from the IEBC before we move on to this constitutional crisis that we are talking about. NASA, first of all, says they need legal action taken against those who are culpable in bungling the August 8th elections. Chiloba, is he one of the people who should go, and will there be an election if Chiloba goes?
Thank you, Michelle, and very sorry to the panel, to yourself and to the viewers for coming in late. I had a bit of challenge on the road. While the three of you are going on, I was pacing up and down on the side shows because of the arguments that were beginning to be generated. First of all, let me congratulate my colleague for being appointed the Speaker of Nyeri. Elected. My apologies. Elected, yes, elected.
Thank you.
And good luck to you.
Thank you very much.
And while he was making that argument, I was wondering why there seems to be a paradigm shift in the way he was approaching the issue of the court having shifted the evidential burden of proof to the IBC when IBC contemptuously, in law we call it contemptuously, because they disregarded the orders of the court to allow the Raila team to have access to the servers. In law, if the court issues an order that you comply and you do not, that is interpretation of the law, the burden shifts.
Yes. In
the sense that you ought to have facilitated that process so that you are vindicated.
Just before you continue, just for a moment, part of the dissenting view of Justice Njoki Ndung'u faulting the majority said it was a fault on the part of the four judges to fault IEBC for refusing access or denying access to their servers when the order was only to allow read-only access, which she says was actually allowed.
And IEBC also at that point, they had also indicated that given more time, they would have even been able to give more access to the lawyers of NASA, given more time. So they had said they had shown willingness to comply, but the hours in which they had also been given, they were not able to give full access as they had, as the lawyers from NASA had wanted. But they had indicated, let us get more time.
Just a moment. Let's just have Dr. Mukwana finish up.
Because they had a chance to speak for a long time, I hope they don't take a lot of what you have given me. First of all, Wakili has to accept that IEBC is in contempt of the court orders.
Yes.
And when you're, yes,
no,
as a lawyer.
But they allowed the read-only access.
After how long?
They did not comply with the orders as granted. You know, as a lawyer, you must be fair to the viewers. That is the interpretation.
He's a lawyer?
Oh, yes,
yes, he is a lawyer.
Okay.
Yeah, so as a lawyer, you must be fair to your viewers. Part of our responsibility as member of the LSK is to educate the public on the law. So speak as a lawyer, not as a speaker.
No, but you see, Daktari...
Wakili, let's ask ourselves, were they in contempt or not?
You see, the issue is here that you know, when the Maraga 4 were issuing their ruling in the first instance, they said that we were not able to go through the voluminous records that have been presented to us in terms of evidence and the documents. And they alleged that there was no sufficient time for them even to write a judgment. And they said that it was not humanly possible. So why is it so difficult when on the other side, IEBC says that you have given us an order, but within the time that you have prescribed, it is not humanly possible for us to give full access to the full extent as demanded by the court. And what we are asking is, given more time by the court, we should be able to do 1, 2, 3.
Michelle, let me explain.
Now, why was it so difficult then for the Supreme Court to then allow them more time?
All right, let's hold that thought. Let's hold that thought. Yeah. Dr. Mukwana, I will give you more time because they seem to be taking more of your time. Pasari,
no, can I tell you something? He's saying given more time. We asked for the servers to be open even before they gave the certificate to Uhuru Kenyatta. We asked. Hold on. Let me tell you something. You're an independent body. Independent. The I is very important. Chebukati, his mandate is to conduct a free, fair and credible election. He doesn't need an order to open the servers. Call both the principals in, bring your IT experts, open the servers. Let me show you that I'm independent. He has the time. He can even do that today. He doesn't need an order to open the servers.
All right, gentlemen, let's not give it time.
Michelle, let me just ask just one question so that Daktari can also answer.
Very briefly, please.
Yeah, just a question then. You see, then what Philomena Mwilu then says is that then that there was the issue of hacking of the system. Because the servers were not opened, then she cast an aspersion as to the fact then that she suspects then that the system was hacked. But you see, unfortunately, that was not proved. And that was relied on to make the judgment.
All right, I would kindly ask both of you to remain quiet for a moment as we hear from Dr. Mukwana. Dr. Mukwana, your thoughts on this?
You know, Michelle, my very good friend Kagusha, last time we had a very interactive and educative show last time. And I really want to beseech him that let's be fair to the viewers, particularly on these ones. And I really hope that my friend was not among the Jubilee lawyers' advisors, because he seems to be taking the same tangent. And that is what the court said, that they misunderstood the petition and jumbled the whole defense. If you remember the remarks of Maraga. Let me say why. Wakili says that the reason why IEBC are in contempt of court, first of all, is not even accepting that the IEBC is in contempt, which I think that's a bit outrageous, with the greatest respect. One of the reasons he's saying that IEBC is not in contempt is because they didn't have enough time. Granted, they didn't have enough time. But that's not the only order that was issued. The other order that was issued was about firewalls. In technical terms, if they had granted the firewalls, access the firewalls, they would have been able to detect what in legal terms, in IT terms, they call the footprints. They didn't need time to issue firewalls. The second one, under the Elections Regulations Act, particularly the technology aspect, Section 44, Regulation 44, it says that when all the technology is set up and is running, IEBC is mandated and obligated to issue what we call a certificate of penetration. A certificate of penetration is evidence, and is a requirement of the law, is evidence that that system has been tested and that there has been no penetration into the system. That also they did not give. Why on earth would you say that they are not in contempt? Granted, they didn't have time. The guys manning the servers in Europe were asleep. Fine, give it to that. Give it to Wakili. How about these two?
But he brings in an important point there,
which is?
Saying that if IEBC did not allow access to the servers, then how did Deputy Chief Justice Philomena Mwilu come to the conclusion that there was hacking of the system? So first of all, before we continue, let's listen in to what Deputy Chief Justice Philomena Mwilu had to say about the servers.
He behaved as as though the provisions of sections 39, 44 and 44A of the Elections Act did not exist. IEBC behaved as though the provisions of Article 88(5) of the Constitution requiring it to, quote, exercise its powers and perform its functions in accordance with the Constitution and national legislation, quote, unquote, did not exist. IEBC failed to observe the mandatory provisions of Article 86 of the Constitution, requiring it to conduct the elections in a simple, accurate, verifiable, secure, accountable, transparent manner. Where is transparency or verifiability when IEBC, contrary to Articles 35 and 47 of our Constitution, was still in the contumacious disobedience of this court's order, refuses to open its servers and logs for inspection?
All right, so there is Deputy Chief Justice Philomena Mwilu there on these servers. Let me come to you.
Okay, I want to take you somewhere, okay? So let's move away from the IEBC and on the burden of proof as well, as Wakili here said. I remember when I sued my husband for paternity, all right? The judge issued an order, go for a DNA, okay? He refused. The judgment was your refusal to show that you're not the father of the children, right? Means that you have something to hide, all right? Or that you are the father of the children. So for me, when you're a judge and you're sitting there and you're telling somebody, show us that what they're alleging hasn't been done, and you're refusing to show it, all right? That means you're leaving us with no other thought but to think the worst of you. So I believe where she's going with this is that whether hacked, whether interfered with, whether whether elections were stolen or not, you had you had the position to actually show us that none of this happened, right. And you refuse. And it's within the law. The law tells you, do this, allow this, open this, but you refuse.
All right, and I want us to move away from this conversation. Let me give you your last thoughts on this. And Kaguche, as you rightly say, IEBC did not have enough time to do that, but it's been a month since that order was given. If they had something to hide, or if they had nothing to hide, rather, a month later, have they given that access to the service?
Let me say something. Okay, there's an interesting example given by Mheshimiwa Pasaris right there about the DNA. But then I want to remind you that this election was not just an it was actually a manual election whereby people cast ballots, forms were filled, and then the issue of the server really just had to do with the issue of transmission. And we had the other opportunity now of going back now to the paper ballot and verifying all that. And remember, one of the things that Joki Ndungu raised in her judgment is that when the forms that were submitted by Orengo and Raila Odinga's team, there was a point where there was no verification that was done by the Maraga 4, especially in counter-checking with what had already been submitted to the registry of the court. And those forms that had already been submitted in the registry had all the security features, the stamps, and the signatures that were required. But there seems, again, because of lack of time from the judges, no verification of these two different aspects. So what we are saying is this: should you have found that you have an issue here with the issue of transmission, and that is what we are calling the process, you also had another opportunity then of going back now to the manual issues, looking at the documents, looking at those forms, not only the ones that were attached by the lawyers, but also the ones that had been submitted. And also, if you're not comfortable and satisfied with that, you still had another opportunity of going back to the ballot boxes and even doing a recount. The issue of agents who are chased really is just a propaganda, which is not here nor there.
All right, Dr. Mukwana, let's hear your thoughts, especially on this vote recount and the fact that Jubilee claims that the court failed to use crucial evidence in determining this petition.
Wakili knows, and without necessarily seeming like we are pulling and tagging with him, with greatest respect, Wakili knows that the court only concentrates on the petition before it.
Yes. Yes.
What was before the court was not a petition for a recount of votes, okay? That is a political line that has been adopted by the other side, without taking sides. I'm neither NASA or Jubilee, but without taking sides. That is a political line. The court cannot address itself to an issue that has not been brought before it. If Jubilee wanted a recount, nothing would have been easier than to apply for the same. Number two, Wakili says that this election was a manual election. Again, with the greatest respect, it was a combination of both.
Yes.
Because after 2013, and after the numerous election-related legislations, technology was embedded in the substratum of this process. And that is why there is the technology regulations on how to regulate on the transmission. So you cannot say this was largely manual, so if the transmission failed, go back to the manual. But even be that as it may, even in the manual section, there were still problems. When the returning officer fails to sign a form, that is not electronic. When the forms, some of the forms, which are prescribed by the law, there's no option, they have no room to change, are missing the security features. They are missing serial numbers. That is nothing electronic. That is purely manual. So in total, Michelle, what I want to advise is this. People must take this talk about going back to count the debates with a pinch of salt. It's a political line. Now, he mentions about the judgment by Njoki Ndung'u, with the greatest respect to her ladyship. What counts is a majority decision. So we should not even be spending much time talking about minority. But I'll come to that. I'll come to that.
Why was that issued and taken so much time
just a moment.
listening to it?
Yes.
If it doesn't count.
I'll explain.
Let's let him finish.
In legal terms, we know that there is a minority decision and there is a majority decision. In terms of decisions in the court, the minority decision is the proper order of the court. However, the law allows that those who are dissenting be given an opportunity to also say why they're dissenting. Exactly. Now, if you look at the way Njoki Ndung'u dissented, with the greatest respect to her leadership, first of all, there was a bit of lack of etiquette for the other judges. I'll tell you why. When the majority were issuing their decision, at no time did they vilify the decision of Njoki Ndung'u. And that is what we call, among the lawyers, is that etiquette. What Njoki Ndung'u ought to have done is to concentrate on her points, which she had. You can't take that away from her.
Actually, her points just vilified.
No.
The ones which actually made
when she says, why didn't the majority read? That is, you're basically throwing barbs at the majority. Give your reasons for dissent, which she had. Give it to her. She had reasons for dissent. However, at one point, it appeared like this was a narrative that was being created so that after that, then the Jubilee side of the wing can clutch on. And it was automatic. Because after the court left, you had Ngatia, Kanzo Ngatia was caught off guard when he said the court is devouring itself, is eating itself. And thereafter, the Jubilee side has clung on the minority decision as the reason why they lost the election. So somebody is tempted to think that the Njoki Ndung'u dissenting opinion was basically influenced so as to form a narrative that the Jubilee will use. And I'll tell you why. Right now, when the other members of the bench were issuing, they said, and the Chief Justice said, so that we can save time, and I don't want us to leave here at 6, we'll make it short. They did their bit. But after that, the other two justices took the entire evening.
Which was important.
Because, and just a moment, Wakili. You know, you're now dealing with politicians, so I really hope that you don't lose the lawyer bit of you, with greatest respect. When the justices were done, the 4 justices, their total work was 179 pages. The other 2, Njoki Ndung'u alone was 440 pages. It was a textbook. 440 pages in 21 days. Even for us who do thesis, Someone tell that
I want us to move away from this and move away from the decision of the judges, the implications now of the majority verdict or the majority decision on the Independent Electoral and Boundaries Commission, because an election date has been set for the 26th of October, but the different political players and the two main presidential candidates, Raila Odinga and Uhuru Kenyatta, have had a lot to say on this election. Let's listen in, first of all, to what President Uhuru Kenyatta had to say about the election.
The court ordered the IEBC to conduct a fresh election in strict conformity with our Constitution and the applicable election laws, and to do so within the 60 days that the Constitution allows. There shall and must be an election within that constitutionally stipulated period.
All right, so first of all, we'll later on listen into what Raila Odinga had to say on that. But Pesaris.
Yeah, I mean, you hear what the president is saying. There shall and must be an election within the 60 days. So we agree on that. So can we then make sure that we don't have a situation where the 10 billion that's been approved again will be bungled up, all right? Because at the end of the day, we want a free, credible election. And it starts from people queuing in, voting on the ballot, the process of transmission, everything that we've invested in. You know, don't take us back to let's go back and now count the ballots. Let's go manual. We came from there. It didn't work. We've got a transmission process now. We've got the CAMs. And you know, for me, going forward in the future, because we've seen in this election now there's a lot of buying of IDs, we want to just say if you've been registered, just come with your fingerprint, because you can't take my finger. Because we've realized now that the right of the voter is also being bought because you're being given money, and this has become the conversation in the country. You know, we improve our systems by the things that go wrong. So we know that counting ballots, printing ballots has always gone wrong. And that's why we're saying this printer that we had and these other ballots that don't have the features, we're not comfortable, right. You know. So let us do the right thing, not for Raila or Uhuru, but for Kenya, for posterity, for us to learn. Because I'll tell you one thing, voter buying is the reason why we have such poor turnout. We capitalize the ID buying. We're capitalizing on poverty. And then, you know, now, for me, I'm saying, if I have my finger, let me come and vote, because I won't sell you my finger, but I'll sell you my ID.
Right. Until you're Sunday. I'll come to you, but other than Uhuru Kenyatta, Raila Odinga says they are ready for this election, but no reforms, no election. Let's listen in to what he had to say.
We will not go to an election until the IEBC rectifies all the mistakes which have now been confirmed by the court, until those individuals who are responsible for these criminal acts are brought to book, removed and prosecuted. Then we are ready to go for elections within 60 days.
Now,
all right, Kaguche.
Yeah, you know, it is true, and I agree with Raila 100%. We need to investigate and get to know who is it that bungled the election. If a form was ever submitted without a stamp and without security features, we want to know who did that. And if the form was a lie, as it is being believed to be, a conspiracy, and sooner than later, this conspiracy will be unraveled. And that is why we must never destroy the evidence. We must not destroy those ballot boxes. We must not destroy all those forms. Let all those forms remain. So that we want to look at these forms that were submitted by Orengo. And we want to compare with what was submitted in the registry. And we want to now to compare. Is it true that there were no security features? Then, if we find that there are no security features, we want to know who is this that gave a form without security features. And the other thing we also want to understand, who is this who failed to stamp and to sign a form? And those people, action must be taken against them. In fact, that should almost be treasonable, I dare say. Right. So I agree completely. The only thing I disagree with is that do not be the DPP, do not be the CID. You are a politician. You've already done your research. You've already done your investigations in the press conferences. And already you have identified in your mind that all these people are the ones who are responsible for this when a proper investigation has not already been conducted. Because again, we see generalities here, we see people casting aspersions, we see people assuming and people propagating a certain political propaganda against certain individuals. What we are saying is this: let us do the election, as of course we also get to understand who is this that bungled the election. Because if you bungled an election, action must be taken against you, and legal action for that matter. And I dare say, one of the things that both Jubilee and NASA must do at this time is to ensure that they have credible agents in all the polling stations so that they are able to mark all their ballots and mark them properly and ensure that those, none of the ballots that this Form 34 is and the Form 34Bs, they need to ensure that all those forms are properly, signed, and they have already, they also take their photos and of course submit them also to their political parties so that we do not have an issue again of after people have left, we hear now that a different form is the one which is actually being submitted to court. So that is one of the things that we expect that will happen at this time. And so when you talk about the irreducible minimum, don't lecture us on names that these are the people now who must be removed. Because as Raila Odinga, you are a stakeholder. You are a contestant in this election. At what point did you get into IEBC, did an investigation, and you are able to now say that this is a person who has done the wrong thing? Again, I'd also
take a short break. Let me just pause you there and listen very briefly to Pasari.
Shouldn't the CEO be the first person to vacate office? And because we agree in principle that you're saying only let's investigate on the ballots and the manual work. But I'm saying we also need to open the servers for Kenyans to understand what went wrong.
All right, we need to take a short break. But even before we do that, we're getting information that IEBC Director of Legal Affairs, Praxidis Tororei, has offered to retire only days after the commission was indicted for bungling the presidential poll. Does this set a precedent among officials within the Independent Electoral and Boundaries Commission? It is a conversation we will be delving into after this short break. For now, however, we'd like to release our viewers watching us on KTN Home. Life and Style is coming up next. The conversation on our Weekend Review continues shortly on KTN News.